If you think you are safe because you have a paid-off home and your parent is on Medicaid, or if you own your home free and clear and think Medicaid would never touch it, what I am about to tell you could save your family's most valuable asset. Because there is a federal program that has been operating in every single state since 1993. It is called the Medicaid Estate Recovery Program. Most people call it MERP, and it is specifically designed to take the home your parent left you in order to repay what Medicaid spent on their nursing home care, their assisted living, their in-home care, or their memory care. This is not a rumor. It is federal law under 42 U.S.C. Section 1396P. And the reason it catches families completely off guard is because of one of the most dangerous misunderstandings in all of elder law. People confuse two completely different legal rules, and that confusion costs families their inheritance. Subscribe right now because what I am going to explain in the next few minutes could protect the home your family has spent a lifetime building. Here is the misunderstanding. When a senior applies for Medicaid long-term care benefits, the Medicaid caseworker tells them that the home is exempt. That is true. While the senior is alive, a home they live in does not count against Medicaid's asset limit. You can own a house and still qualify. Most seniors hear the word exempt and understand it to mean the home is safe. They relax. They think Medicaid will cover the nursing home, the family keeps the house, and everything works out. That understanding is half right and half dangerously wrong. The home is exempt from the asset limit for purposes of qualifying for Medicaid while you are alive. But the word exempt does not mean the same thing as the word protected. It does not mean the home is permanently safe from the government. The moment the Medicaid recipient dies, an entirely different set of rules takes over. And those rules say the state can come after the home to repay every dollar Medicaid spent. Let me walk you through exactly how this happens, so you understand the mechanics. A senior, we will call Margaret, is 78 years old. She has a paid-off home worth $350,000. She has a small amount of savings. She is diagnosed with dementia and eventually needs nursing home care. She applies for Medicaid. The caseworker tells her the home is exempt. Medicaid approves her. She moves into the nursing home. Medicaid begins paying her care costs. The average nursing home in 2026 costs between $9,000 and $10,000 per month depending on location and level of care. Over 2 years, Medicaid has paid approximately $220,000 on Margaret's behalf. Margaret passes away. Her 2 adult children are the heirs. They are expecting to sell the family home and split the proceeds. Instead, they receive a letter from the state's Medicaid Estate Recovery Program. The letter informs them that the state is filing a claim against Margaret's estate for $220,000. The only thing of value in Margaret's estate is the home. The state intends to place a lien on the home. The family cannot sell it, transfer it, or do anything with it until that $220,000 lien is satisfied. The inheritance they thought was theirs is effectively gone. This scenario plays out in thousands of families across America every single year. And the reason it keeps happening is that nobody told them about MERP when Margaret applied for Medicaid. Or, if they were told, the disclosure happened in dense legal language buried in paperwork that nobody read carefully in the middle of a family crisis. If you are finding this urgent and important, subscribe right now. Because I cover elder law protections that affect your family's financial security every week. And the information I am about to give you about how to protect a home from MERP is the kind of information most families only hear about from an attorney after it is too late. Now let me explain the specific federal law that makes MERP possible. The Omnibus Budget Reconciliation Act of 1993, known as OBRA 93, made Medicaid estate recovery mandatory in all 50 states. Before 1993, estate recovery was voluntary, up to each state's discretion, and most states did not aggressively pursue it. OBRA 93 changed that. It required every state to establish a program to seek reimbursement from the estates of Medicaid recipients who were 55 or older when they received long-term care services. That age threshold of 55 is important. It means that MERP applies not just to people who use Medicaid in their 80s, it applies to anyone who receives Medicaid-covered long-term care after their 55th birthday. So a 58-year-old with multiple sclerosis who uses Medicaid waiver services at home is subject to MERP. A 62-year-old with early-onset Alzheimer's who enters a memory care facility is subject to MERP. This is not only an issue for people who are very old. It is an issue for anyone over 55 who relies on Medicaid for long-term care of any kind. The types of Medicaid services covered by MERP are extensive. Nursing home care, assisted living facility care in states that cover it, home and community-based services, which are the waiver programs that pay for in-home care, adult day programs, and similar services, hospital and prescription drug costs related to long-term care, and in some states, Medicaid services beyond just long-term care. The Medicaid agency cannot collect more than it actually spent. If Medicaid paid $153,000 in long-term care costs and the estate is worth $400,000, the state can only recover $153,000. But if Medicaid paid $300,000 and the estate is worth only $280,000, the state can take the entire estate. Now let me tell you about what I call the geography of danger, because where you live makes an enormous difference in how aggressively your state will pursue MERP recovery. There are currently 23 states plus the District of Columbia that use what is called probate-only recovery. In these states, MERP can only pursue assets that pass through the probate process. Probate is the court process that distributes assets held in the deceased person's name alone according to their will or state law. In probate-only states, certain ownership structures can protect assets because they pass outside of probate entirely. Joint tenancy with right of survivorship, transfer on death designations, and certain trust structures can move assets out of the probate estate and therefore out of MERP's reach in these states. But then there are the 27 states that use expanded recovery. In expanded recovery states, MERP can pursue not just probate assets, but also jointly held property, assets held in living trusts, life estates, and other non-probate transfers. If you live in an expanded recovery state, the strategies that protect families in probate-only states may not work for you. You face a significantly more aggressive version of MERP, and you need state-specific legal planning immediately. Knowing which type of state you live in is the first piece of information you need when protecting a home from MERP. Let me tell you about the 5-year look-back rule, because this is the second major trap that catches families off guard when they try to protect a home from MERP on their own. When a senior applies for Medicaid, the state looks back 5 years in the applicant's financial records. If the applicant transferred any assets, including their home, to another person for less than fair market value during that 5-year period, Medicaid imposes a penalty period. During the penalty period, Medicaid will not pay for the applicant's care, even if they qualify financially. The length of the penalty is calculated based on the value of what was transferred. This means you cannot simply give the house to your children the month before your parent enters a nursing home. If that transfer happened within the last 5 years, Medicaid will see it and will impose a penalty that could leave your parent without Medicaid coverage for months or years. The look-back rule makes last-minute home transfers essentially useless as a MERP protection strategy. Hey, 73% of people watching right now are not subscribed. The information I am covering right now is the kind of elder law planning that most families only encounter in a crisis. Subscribe now and get ahead of it before it becomes your family's crisis. Here's the good news. There are real, legal protection strategies for the home. But as I just said, most of them require starting the process years before Medicaid is needed. Let me walk you through the most important ones. The first and most powerful strategy is an irrevocable Medicaid Asset Protection Trust, sometimes called a MAPT. In a MAPT, the senior transfers ownership of the home into an irrevocable trust. They can still live in the home and receive income from it. But because they no longer legally own it, it is not part of their estate when they die, and MERP cannot pursue it. The catch is timing. The transfer to the MAPT must happen at least 5 years before the senior applies for Medicaid. That 5-year waiting period is the look-back period working against you. If you start a MAPT when your parent is 70 and healthy, it is fully protected by 75. If you wait until they are 80 and already showing signs of dementia, you may not have 5 years left to clear the look-back period. MAPTs must be drafted by an elder law attorney. They are not something to do with online templates, but they are highly effective when done correctly and early enough. The second strategy is the Ladybird deed, also called an enhanced life estate deed. A Ladybird deed is available in 5 states: Florida, Michigan, Texas, Vermont, and West Virginia. It allows a senior to retain full control of their home and the right to live there for their lifetime. while designating who receives the home at death. The key feature is that the transfer at death happens automatically without going through probate. Because it bypasses probate, in probate-only states a ladybird deed can protect the home from MERP entirely. The transfer is not subject to the 5-year look-back rule because the senior retains control and the transfer does not happen until death. In Florida especially, the ladybird deed combined with the state's strong homestead protections can be a powerful planning tool. Ladybird deed costs typically range from $300 to $1,500 when drafted by an elder law attorney. For families in those 5 states with appropriate circumstances, this is one of the most cost-effective MERP protections available. The third strategy is the child caregiver exception. Under federal Medicaid rules, a senior can transfer their home to an adult child who meets 2 specific requirements. First, the child must have lived in the parent's home for at least 2 years before the parent entered a nursing home or received institutionalized care. Second, the child must have provided care during that time that delayed the parent's need for institutional care. If both conditions are met, the transfer of the home to that child is exempt from the 5-year look-back penalty. This is a genuine legal protection that many families qualify for without realizing it. If an adult child has been living with and caring for an aging parent, that caregiver may be able to receive the home without triggering a Medicaid penalty, removing it from MERP's reach. Documentation is critical. The caregiver should have records of the care they provided, their period of residence, and ideally a physician's statement confirming that their care delayed institutionalization. The fourth strategy is the sibling exemption. If a sibling of the Medicaid applicant has been living in the home and has an equity interest in it for at least 1 year before the applicant entered institutional care, the home can be transferred to that sibling without a Medicaid penalty. The sibling exemption applies to a narrower set of family situations, but is worth exploring if you have a family member who has been sharing the home. Now let me tell you about the automatic protections that MERP cannot overcome regardless of planning. Under federal law, states cannot pursue MERP recovery while a surviving spouse is alive. If a Medicaid recipient is married, the state cannot touch the home or file a claim against the estate while the healthy spouse is living there. This is one of the most important spousal protections in elder law. Additionally, states cannot pursue recovery if there is a surviving child under 21 or a child of any age who is blind or permanently and totally disabled under Social Security standards. These protected individuals essentially create an automatic exemption from MERP. If they exist, the state must wait. And in practice, because these protected individuals often inherit the property when the exemption eventually ends, recovery may never happen at all. There are also hardship waivers available in most states. If MERP recovery would impose an undue hardship on the heirs, states are required by federal law to establish a waiver process. Each state defines hardship differently. In Texas, for example, if the homestead value is under $100,000 and one or more heirs have family income below $46,950 for one person, adjusted annually, the state may waive its claim. The critical thing to understand about hardship waivers is that they are not automatic. The heirs must proactively apply for the waiver and provide documentation. If you never ask, the state will not grant one. Let me also mention the federal legislative effort currently underway. House Resolution 6951, the Stop Unfair Medicaid Recoveries Act, was introduced in the 119th Congress during the 2025 to 2026 session. It would repeal the federal mandate for MERP entirely, eliminating the requirement that states pursue estate recovery. It would also limit pre-death liens. As of May 2026, the bill has been introduced but has not advanced in Congress. If it passes, the national MERP landscape would change dramatically. But it has not passed. The law as it currently stands requires MERP in all 50 states. Do not plan around legislation that has not yet been enacted. Here is the bottom line and your action plan. If you are 55 or older, and you think you might need Medicaid long-term care services at some point, or if your parent is in that situation, you need to consult with a certified elder law attorney or a certified Medicaid planner now. Not when the nursing home becomes necessary. Not when the diagnosis comes. Now. Because the strategies that protect the home require years of advance planning to work. AMAPT requires 5 years to clear the look-back period. If you start today, you have 5 years of protection ahead of you. If you wait until the crisis, those options close. Specifically, first, find out which type of MERP state you live in, probate only or expanded recovery, because that determines which strategies are available. Second, if you are in one of the 5 Ladybird deed states, ask an elder law attorney about whether that deed makes sense for your situation. Third, if an adult child has been living in and caring for the parent's home, document that caregiving now and explore the child caregiver exception. Fourth, if a hardship situation exists, know that you must proactively apply for the waiver after death. It will not be offered automatically. Fifth, for any transfer or planning strategy involving Medicaid, work only with a qualified elder law attorney who knows your state's specific MERP rules. Do not use online templates. Do not rely on general advice. State-by-state differences are enormous, and what works in Florida may not work in New York. Sixth, talk to your family about this now. Adult children who do not know that MERP exists cannot protect themselves or their parents. Share this information. The families who lose the home to MERP are almost always the families who simply did not know the trap was there. The home your family worked to pay off over decades is one of the most significant assets most Americans ever hold. It is the center of family memory and financial security. Medicaid's Estate Recovery Program does not care about any of that. It is a debt collection mechanism for a federal program, and it is good at its job. But it has legal limits and legal exceptions. And if you know what they are and you plan accordingly, the home does not have to be part of that equation. Subscribe right now so you never miss the next video on this channel, where I am covering the specific state-by-state differences in MERP and the protection strategies that work best in each one. This is educational content only and not legal advice. Every situation is different, every state is different, and the right strategy for your family requires the guidance of a qualified elder law attorney. Get that guidance before the crisis arrives, not after.